The transfer of invasive aquatic species through ships' ballast water has long been recognized as one of the most serious environmental threats facing the global maritime industry. Ships take in seawater as ballast to maintain stability, but when this water is discharged at another port, it may contain microscopic organisms such as plankton, bacteria, and larvae. When introduced into new ecosystems, these non-native species can proliferate uncontrollably, disrupting local ecosystems and damaging biodiversity. Notorious examples include the zebra mussel invasion in North America and the comb jelly outbreak in the Black Sea, both of which caused long-term ecological and economic consequences. To address this issue, the International Maritime Organization, IMO, adopted the International Convention for the Control and Management of Ships' Ballast Water and Sediments, 2004 BWM Convention. This landmark international instrument established a global regulatory framework designed to prevent the spread of harmful aquatic organisms through ballast water operations. The convention requires ships to manage, exchange, or treat ballast water before discharge, ensuring that harmful species are not released into new marine environments. Under Article 18, entry into force of the convention, the treaty would enter into force 12 months after the date on which not less than 30 states, representing at least 35% of the gross tonnage of the world's merchant shipping, had either signed it without reservation or deposited the requisite instruments of ratification, acceptance, approval, or accession in accordance with Article 17. For states that deposited their instruments after this threshold was reached, but before the convention's entry into force, their participation would take effect either on the entry into force date or 3 months after deposit, whichever was later. For states joining after the convention entered into force, their ratification would take effect 3 months after deposit. Furthermore, under Paragraph 4, any future amendment accepted under Article 19 automatically applies to states depositing their instruments thereafter. After fulfilling these conditions, the BWM Convention entered into force globally on the 8th of September 2017. Malaysia ratified the convention on the 27th of September 2010, and it entered into force within Malaysian waters on the 8th of September 2017, demonstrating Malaysia's commitment to marine environmental protection and alignment with international maritime standards. Under Article 18 and subsequent IMO resolutions, the convention establishes 2 principal operational standards for managing ballast water. The first, Regulation D1, Ballast Water Exchange Standard, requires ships to conduct ballast water exchange in the open ocean at least 200 nautical miles from the nearest land and in waters not less than 200 meters deep. The second, Regulation D2, Ballast Water Performance Standard, mandates that ships treat their ballast water using an IMO-approved ballast water treatment system, BWTS, that removes or neutralizes organisms before discharge. Every ship must therefore carry an approved ballast water management plan, BWMP, a ballast water record book, a ballast water treatment system type approval certificate, and an International Ballast Water Management Certificate, IBWMC. The gradual transition from D1 to D2 compliance allows ship owners adequate time to install approved treatment systems, typically coinciding with the renewal of their International Oil Pollution Prevention IOPP certificate. In Malaysia, the Marine Department Malaysia, Jabatan Laut Malaysia JLM, is the competent authority responsible for implementing, inspecting, and certifying compliance with the convention. Malaysia officially enforced it on the 8th of September 2010 through Malaysia Shipping Notice MSN MF3 2017, requiring all Malaysian and foreign flagged vessels of 400 gross tonnage (GT) and above designed to carry ballast water to comply. Newly built ships must install approved D2 systems, while existing ships may temporarily operate under D1 exchange until their next IOPP renewal, after which D2 compliance becomes mandatory. This phased approach ensures both environmental protection and operational practicality. Under MSN 07-2017, ships carrying ballast water from outside Malaysian waters must comply with pre-arrival reporting and operational requirements. The master or agent must submit a ballast water reporting form to the port officer at least 24 hours before arrival, confirming that the ship has performed the required ballast management, either exchange, treatment, or discharge to reception facilities. ballast water discharge within Malaysian waters is prohibited without port officer approval. Ships arriving from foreign ports intending to release ballast in Malaysia must have conducted the exchange at least 200 nautical miles from land in 200-meter deep waters. Or, if that is unsafe, at least 50 nautical miles from land and 200 meters deep, as permitted under IMO Resolution MEPC.1453. If these conditions cannot be fulfilled, the master must provide written justification to the port officer. Ships using an approved BWTS under D2 are exempted from oceanic exchange. Acknowledging Malaysia's unique maritime geography, domestic exemptions were introduced through MSN 08-2017 and MSN 14-2020. The convention does not apply to ships operating solely within peninsular Malaysia, Sabah, Sarawak, or the federal territory of Labuan, or between these regions without entering international waters. However, Malaysian-flagged ships of 400 GT and above, trading between peninsular Malaysia and East Malaysia, must perform ballast exchange at least 100 nautical miles from land in water not less than 50 meters deep. These ships must still carry an International Ballast Water Management Certificate, a Ballast Water Management Plan, and a Ballast Water Record Book on board. Should a vessel begin international operations, it must upgrade to full D2 compliance, install an IMO-approved BWTS, and renew its IBWMC accordingly. Under Regulation E1 of the Convention, ships of 400 gross tonnage and above, excluding floating platforms, FSUs, and FPSOs, are subject to surveys for compliance. Regulation E2 mandates that, upon successful completion of these surveys, the administration must issue an International Ballast Water Management Certificate, IBWMC 2004. The UUM-BOLE, with a gross tonnage of 28,927 GT, clearly exceeds the 400 GT threshold and therefore falls under Regulation E1. Consequently, the vessel must undergo the prescribed initial, renewal, intermediate, and additional surveys, after which the Marine Department Malaysia shall issue an IBWMC 2004 under Regulation E2, confirming that the ship meets all technical and operational standards. The UUM-BOLE, owned and operated by UUM Oil Tanker CN BHD, is a Malaysian-flagged oil tanker registered at the Port of Registry, Penang. With a gross tonnage of 28,927, deadweight of 39,276 tons, IMO number 9315848, and classification under the Korean Register, KR, the ship's dimensions are 222.17 meters in length overall, 30.0 meters in breadth, and 16.80 meters in molded depth. Its keel was laid on the 7th of March 2005, classifying it as an existing ship under IMO definitions. Before the 2017 entry into force, the vessel complied with Regulation D1, performing open ocean ballast exchange. However, following its IOP renewal after 8th of September 2017, the UUM-BOLE is now required to fully comply with Regulation D2, install an approved BWTS, update its ballast water management plan, and maintain a ballast water record book on board. If the UUM-BOLE operates solely within Malaysian waters, for example, on domestic routes between Penang and Labuan, it may qualify for domestic exemption under MSN 08-2017 and MSN 14-2020, provided it performs ballast exchange 100 nautical miles offshore in waters not less than 50 meters deep and keeps detailed ballast records. However, if the ship resumes international voyages to Singapore, Thailand, or Indonesia, it must maintain full D2 compliance, with its BWTS fully operational and certified to ensure no untreated ballast is discharged. The Marine Department Malaysia would issue or endorse the IBWMC following successful inspection and verification under Regulation E2. Crucially, Malaysia's Merchant Shipping Ordinance 1952, MSO 1952, provides the national legal backbone that underpins this international framework. Section 276, Information about Ship Stability, requires ships whose keel was laid after the ordinance's commencement to carry on board approved written stability information for the guidance of the master in loading and ballasting the ship. This information, ordinarily based on an inclining test, must be updated whenever significant modifications are made. The Surveyor General of Ships may approve alternative data, such as a sister ship test or dispensation for bulk liquid ore designs, and a copy must be sent to the Surveyor General. Failure to comply attracts a fine up to RM 10,000. Functionally, this ties directly to ballast compliance. A master cannot manage ballast safely for D1 exchanges or D2 operations without accurate stability data, making Section 276 fundamental to the safe execution of ballast operations. Further, Section 306G, Powers of Director of Marine in cases of non-compliance, empowers the Director of Marine, when a notice related to pollution control is ignored, to carry out corrective actions at the owner's expense. If oil or harmful substances escape due to non-compliance, the director may act to reduce pollution or remove its effects. All expenses become a government debt and a charge on the ship, which may be detained until payment or acceptable security is provided. While the BWM Convention targets biological contamination, Section 306G strengthens Malaysia's enforcement capacity for incidents involving harmful discharges, providing detention and cost recovery powers that deter negligence in ballast operations. Disputes concerning seaworthiness or compliance may be brought before the Court of Survey under Section 344, where a judge and assessors may inspect the ship, order unloading or removal of cargo or ballast, and appoint experts to report on technical issues. The court may release or finally detain a vessel, offering a transparent due process mechanism for resolving technical and safety disputes related to ballast management. Meanwhile, Section 382, Powers of Removal extend to tackle, cargo, etc., clarifies that removal provisions apply equally to articles or things forming part of the ballast, treating them as part of the vessel. Thus, if a casualty scatters ballast or related equipment into navigable waters, authorities can recover and dispose of such materials swiftly to maintain navigation safety. Additionally, Section 445, Minister may make port rules, gives the Minister of Transport power to make port rules regulating traffic, anchorage, mooring, cargo handling, and, importantly, reception facilities for oily residues, harmful substances, noxious liquids, sewage, and garbage. This section allows ports to ensure the safe and efficient management of residues and sediments linked to ballast operations, complementing the BWM Convention. Breaches may result in fines up to Rm 10,000 or imprisonment up to 1 year. Finally, Section 464, Throwing Ballast into Ports, prohibits casting or throwing ballast or rubbish likely to form a bank or shoal or otherwise impede navigation within port limits without the port officer's permission. Violators, including the ship's master, may be fined up to Rm 250, plus the cost of removal. While the BWM Convention addresses ballast water pollution, Section 464 targets solid ballast and navigational safety, closing two separate but related risk pathways: biological contamination and physical obstruction. Together, the BWM Convention 2004 and the Merchant Shipping Ordinance 1952 create a comprehensive maritime governance framework in Malaysia. The convention defines international obligations on ballast water management, while the MSO 1952 embeds domestic enforcement, safety, and pollution control powers. For the UUM-BOLE, this means maintaining accurate stability data, conducting ballast operations safely, complying with D2 performance standards, and holding a valid IBWMC 2004 certified by the Marine Department Malaysia. This integrated approach ensures that Malaysia's shipping operations remain safe, clean, and sustainable, fully aligned with the IMO's mission of clean ships, clean seas.